Oh, hey guys. So I thought that the Darrin Henson lawsuit against Sony for the Bye 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 dance sequence, I thought, well, nothing's really happened since April. So I checked Court Listener and it was still like there was nothing new added. And I hadn't had any pacer alerts. So I was like, oh, okay. That's really odd because I would have been by this point expecting a response from Sony. But there was none. So I was like, okay, what is going on? So I logged into Pacer, and sure enough, there's actually been quite a lot has happened. So firstly, the parties all entered into mediation, and it sounds like that went to shit because, they obviously didn't work anything out. Because we are now 2 days ago, this amended complaint was filed by Darrin Henson, which I will go through in a minute. The other bit that happened as well, which is I'm not going to go into it and I'm not going to read the documents because it's not really relevant to the case itself. There's an attorney called James Walker. He filed a motion for a lien. Now, a lien is basically it's a charge. So if Darrin Henson wins compensatory damages, a lien basically says to the court, before you give this guy all this money, he owes me money. So, we need to resolve that and, decide whether I can claim that, what's owed to me out of that money, and then you give him the rest, etc., etc. So it's like buying a house. When you borrow money, you got a mortgage from your bank and you use that to buy a house. The bank then puts a charge on the property, on the land, on the title deeds of the property to say, hey, if the owners, if this person here who is the title owner of this property sells it, before they get all their money, they have this outstanding debt with us, which needs to be paid back out of that money, and then they get what's left. And the lien is essentially the same thing. He says the lien is for legal work that he did in connection with this case. I've never seen anything filed from this person. All the filings representing Darrin Henson have been from a different law firm. So I don't know how much he did. He might have done some initial background work and then Darrin Henson decided to go with someone else. Quite common. So I can't imagine his bill is big, but he's saying, look, Darrin Henson didn't pay for the work I did. So I want this money out of anything he receives in compensation. So I'm not going to go into that because it's just a side piece. It's quite irrelevant. However, the first request for a lien that he filed was rejected because he failed to seek leave from the court to file it, which was a rookie mistake for an attorney. Anyway, so we'll then move on to this. Now, I have not read this yet. So, Darrin Henson has filed leave to amend his complaint. Okay, now this is not a long complaint at all, but he has added some new defendants to this. There's obviously Sony Music Entertainment, Richmond Street Productions, Epic Games. So I had a feeling that Epic Games was going to come into this. The Epic Games, obviously, as I did my video on Epic Games and their previous lawsuits for, using dance routines in their Fortnite game. And I did a whole PowerPoint on why I think this one is going to be different. I am not surprised. In my video, I said Epic Games are not currently a defendant, but I can foresee them becoming one. And sure enough, they are. Also, Lance Bass, one of the members of NSYNC. I don't know why just Lance Bass just yet. It's not the other members. It's not NSYNC as a band. But Lance Bass as an individual is being sued. So is Nick Pauley, who was Dancepool, the guy who did the Deadpool and Wolverine dance sequence in the opening credits. Again, I anticipated that because he's been paid to do a job which is entirely based on doing that dance routine. So he has profited from this dance. So I've said in my previous video, I can see him being added as a defendant. I really can. And sure enough, he has. So there are two causes of action: copyright infringement and vicarious copyright infringement. So I'm curious to, I mean, everyone else I can understand. Lance Bass, I'm curious why him and not anyone else. Now, one thing I can possibly think is I've seen him get involved in some TikTok collaborations with, professional dancers on TikTok who have done NSYNC dance routines. And there would have been like revenue from that potentially, but I don't know. We will find out as we go through it. This is about a 10-page long, so it's quite a short complaint. Okay, so introduction. This is an action by Darrin Henson, an individual seeking a declaration of his exclusive ownership interest in and to the creative work that he created in 1999, and that subsequently became associated with the musical work entitled Bye 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 by the recording artist professionally known collectively as NSYNC, to recover damages from the infringement of his copyright in and to the work by defendants Sony Music Entertainment, Richmond Street Productions, Epic Games, Lance Bass, Nicholas Pauley, and Does 1 through 10. Okay, so more defendants could be added at some point. And to enjoin defendants from future infringement. Defendants used, reproduced, distributed, and publicly displayed through unauthorized licensing and then via film, video game application, and various public performances, Henson's copywritten work. So the parties. Plaintiff Darrin Henson, hereafter plaintiff or Henson, is a resident of the state of Georgia and the creator of the work, a multinational hit dance that Henson authorized NSYNC to use for non-monetary advertising and promotional purposes in relationship to the musical work Bye Bye Bye, a musical work that was first performed by NSYNC with the work on October 28, 1999, at the first ever Radio Music Awards in Las Vegas, Nevada, which was pre-recorded and then distributed and aired live on the WB and its then local affiliate networks. Okay. Sony Music Entertainment is a Delaware general partnership with its principal place of business at 25 Madison Avenue, New York. SME does business in California. Los Angeles. I'm not going to read the whole address because that's irrelevant. On information and belief, SME was originally formed in 2004 under the name BSO, and later that year became Sony BMG Music Entertainment, which was a joint venture between Sony Corporation of America and Bertelsmann AG from about March 2004 until about October 2008, and the same was renamed SME, effective December 31st, 2008. On information and belief, SME gained ownership of the Zomba Group, the original owner of the promotional video created for the musical work Bye Bye Bye, around this time when Sony Corporation of America purchased Bertelsmann 50% stake in the joint venture. Bertelsmann purchased the Zomba Group in 2002. This acquisition resulted in SME owning the rights in and to the musical work Bye 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 and its related promotional video. Richmond Street Productions, on information and belief, is a California limited liability company created by Marvel Studios, with its principal place of business in California, Los Angeles. On information and belief, SME gave RSP a non-exclusive license to reproduce the chorus of the work as an interrupted dance in the main title opening sequence of Deadpool and Wolverine, and to exhibit and distribute the same within the film, and to use the same as advertising and promotional material for the film. So effectively, he is also suing Marvel, a subsidiary company owned by Marvel. RSP made such use of the work in the film was distributed by Walt Disney Studio Motion Pictures, and the film was promoted by way of various public performances by defendant Nicholas Pauley. Epic Games is a Maryland corporation with its principal place of business in North Carolina. Epic Games is registered to do business in California, and on information and belief, it does business in Los Angeles. On information and belief, SME gave Epic Games a non-exclusive right to use the work in its entirety as an emote, an in-game character, animation, dance, gesture, action, or other movement in its video game Fortnite for a limited term, and to license the same to third parties for purposes of distribution, sale, license, and or promotion of Fortnite. Epic Games made such use of the work and profited from the sale of the related emote. On information and belief, Lance Bass, a member of NSYNC, is a resident of and does business in Los Angeles, California. On information and belief, in May of 2024, Bass partnered with Marriott to host an interactive fan experience wherein he taught the work without a valid license to exploit the work for profit. On information and belief, Bass exploited the work at the fan experience and profited from the instruction of the work. Okay, so he did like an interactive sort of fan dance teaching, dance lesson session, learning the routine. On information and belief, Nicholas Pauley, a dancer and choreographer, was hired by RSP to perform the work in Deadpool and Wolverine and for the promotional activities related to the film. Pauley has subsequently performed the work at various workshops and public appearances for which he was paid to attend, without a license to make such use of the work for profit. Oh dear. Defendants 1 through 7 inclusive are sued herein under fictitious names. Their true names and or capacities are unknown to plaintiff. For example, plaintiff knows that John Likens sold the idea of doing the work in Deadpool and Wolverine to Ryan Reynolds. He knows that Disney distributed Deadpool and Wolverine, and he knows that the defendants, including but not limited to SME, have entered into other licenses that infringe his work. Plaintiff either cannot lawfully disclose this information at this time, does not yet know exactly what harm their acts have caused him directly, and or does not yet know the role of each in the specific harm asserted herein. Therefore, when things like true names and capacities are ascertained, plaintiff will amend this complaint by inserting the same herein. Okay, so I just want to read this actually. So this is Johnny Likens. One thing I never thought I would find myself doing in my career would be learning the dance moves to NSYNC's Bye Bye Bye, to try and sell the idea of a dance in Deadpool to Ryan Reynolds and Sean Levy for their opening title sequence, but here we are. Behold, a never-before-seen, very rare behind-the-scenes clip of me in the motion capture suit learning the moves, and the motion test footage that I pitched to the filmmakers to showcase how funny it could be to intercut the idea into the sequence. Director Sean Levy was later quoted in an interview with someone saying, "This concept changed the entire DNA of the opening sequence. You never know where a great idea is going to come from. It's been wild to see this little idea come to life and entertain fans on screens all over the world." Okay. On information and belief at all times, material herein, each of the defendants was the agent and or employee of some or all of the other defendants, and in doing the things hereinafter alleged, was acting within the course and scope of such agency and or employment, making their acts and or omissions attributable to the dependent that employed them pursuant to the legal doctrine of vicarious liability. Okay, so most people will know this already, but just in case you don't, vicarious liability, so that's where, I don't know, say an employer hires a person. So obviously Nick Pauley was hired by Richmond Street Productions to perform the dance. That was literally what he was hired for. So Nick Pauley is being sued as an individual. Richmond Street Productions is being sued for using the license, but they're also going to be sued in their capacity as employer of Nick Pauley. They are vicariously liable for Nick Pauley's actions because they were his employer, if that makes sense. So, a person working for a company, if that person is negligent, you can sue the employer because they are responsible for their employees. And that is called vicarious liability. So it's not direct liability, but, as the employer, it's your problem, your employer, your employee, your problem. Okay. SME and some or all of the other dependents had a licensor-licensee relationship. The dependents that obtained a license from SME used the work with SME's authorization. Each time a dependent made use of the work pursuant to a license from SME, Henson's copyright was infringed, and more than one party was responsible: the licensee that used the work and SME who authorized the use. Since SME and the licensing defendants are at fault together for the licensed uses, they are liable for any damage such use caused jointly and severally. Accordingly, to avoid inconsistent rulings and preclusion, all tortfeasors are sued collectively herein. The dependents that obtained a license to use the work from SME do not have an affirmative defense against Henson's claims of copyright infringement because they licensed the work pursuant to only copyright registrations for the promotional video that was created and used to advertise and promote the musical work Bye Bye Bye. These copyrights are motion picture copyrights that do not protect the underlying elements used therein, such as the musical work Bye 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 and or the work. He's talking about the dance. These registrations do not contain any disclaimers for any pre-existing copywritten or copyrightable work, do not assert any claim to creative work contained therein, and do not assert that any of the work therein was a work made for hire. Accordingly, all or most of the licensing defendants obtained a separate license from SME for the use of the underlying musical work. None of the defendants obtained a license from Henson to use the underlying work. The defendants' actions of entering into licensor-licensee relationships with SME and or entering into contracts with SME that are supported by valuable consideration for the ability to make authorized use of the work for profit concede the fact that the work is an original copyrightable subject matter and foreclose any bad faith arguments to the contrary that are employed merely to avoid liability. Spelling mistake there. Employed merely to avoid liability to Henson for infringement. The Copyright Act of 1976 provides that copyright ownership vests initially in the author or authors of the work. The only exception to this is a work made for hire. The Act defines a work for hire as 1. A work prepared by an employee within the scope of his or her employment, or 2. A work specially ordered or commissioned for use as a contribution to a collective work as part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as answer material for a test, or as an atlas, if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. SME has had roughly 2 years since receiving notice of infringement from Henson in 2024 to locate its predecessor in interest written work made for hire agreement and or other written transfer of interest in the work from Henson to Zomma or SME. It cannot find any such document. Roughly translated, SME is screwed. So jurisdiction. So this Henson has actually changed the jurisdiction. So initially the claims were being pursued in Georgia, and he is now seeking transfer to California. This action is brought, and this court has subject matter pursuant to Section 101, Sections 1331, 1338, and 2201. The court has personal jurisdiction over the defendants. As alleged within paragraphs 2 through 13 incorporated herein, all defendants either reside in Los Angeles, California, and or solicit, transact, and or are doing business within Los Angeles, California, and have committed unlawful and tortious acts both within and outside California, causing injury in California. Plaintiff's claims arise out of the conduct that gives rise to personal jurisdiction over defendants. Okay, facts common to all claims. Henson's ownership. So most of this we'll already know. He was hired to create the work for NSYNC's first ever live performance of Bye 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 in October 1999 by, them at the time, their manager and creator, Lou Pearlman. Henson received a call from NSYNC's day-to-day manager, Johnny Wright, to choreograph the work. For the band's first promotional performance of the unreleased musical work entitled Bye 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 at the first ever Radio Music Awards in Las Vegas, Nevada. Henson subsequently flew to Las Vegas to choreograph the work. He spent 1 hour in a hotel room alone with a speaker listening to Bye 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 and creating the work. He did not sign a made for hire agreement prior to the creation of the work. And as such, by its creation alone, he becomes sole owner of the work. When I say the work, I'm obviously referring to the dance. He subsequently taught the unmodified work to NSYNC, who performed the unmodified dance live the very same day, October 28th, 1999. That performance was pre-recorded, edited, and then distributed and aired live on the WB and its affiliate networks the same day. A true and correct copy of the Radio Music Awards performance can be viewed at the following link. So there's a link there. I'm not going to open it though. NSYNC subsequently performed the work live on multiple occasions in 1999, including but not limited to during its promotional appearance on the Rosie O'Donnell show and during the group's promotional NSYNC in concert second to none tour. True and correct copies of these performances can be viewed at the following links. The promotional video for Bye 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 was made during the period between January 9th and January 11th, 2000, and released on January 21st, 2000. Zomba obtained copyright registration for the promotional video on December 10th, 2001, for a publication date of January 21st, 2000. The registration was for a motion picture, and it did not disclaim any existing work or indicate that any work was made pursuant to a work made for hire agreement. Zomba obtained a second registration for the promotional video on March 23rd, 2006 for the same publication date, and it too did not disclaim any existing work therein or indicate that any work was made pursuant to a work made for hire agreement. According to the United States Copyright Office, Circular 45, a copyright on a motion picture protects only the expression fixed in the motion picture, such as the camera work, dialogue, sounds, etc. It does not cover the underlying idea or concept behind a work or any characters portrayed in it. Therefore, the motion picture registrations do not provide SOMBA or SME with registered ownership of the underlying work, nor do they provide any actual notice to Henson of any conflicting ownership claim in and to the underlying work. Henson has not signed any written transfer of interest in and to the work to any third party to date. Until 2024, Henson was wholly unaware of any use of the work for profit by anyone other than himself. The same year, Zomba obtained registration for the promotional video. Plaintiff was creating and releasing Darrin's Dance Grooves, a first-of-its-kind aerobics-style dance instructional video on VHS that sold over 3 million copies, earning Plaintiff millions and making it one of the most successful dance videos of all time. Relatedly, Plaintiff has been publicly holding himself out as the sole owner of the work throughout the years in various public interviews and during live workshops, wherein he taught the dance, completely unchallenged, including but not limited to within his documentary Darrin's Dance Grooves, The Untold Darrin Henson Story, that premiered on ALLBLK on April 20th, 2023. Based on the facts contained within paragraphs 19 through 33 incorporated herein by reference, Henson obtained copyright registration for the work on November 19th, 2025. In relevant part, Henson's copyright in and to the work covers the visual elements created for the chorus of the musical work Bye Bye Bye. Henson obtained registration of this work more than 5 years after publication. Therefore, Henson is not entitled to a presumption of validity as to the facts stated in this certificate. Additionally, Henson obtained copyright registration after the infringement commenced. Therefore, he is foreclosed from seeking statutory damages and attorney's fees. Henson may, however, seek to recover his attorney's fees and costs related to this action as a sanction against defendants for bad faith or fraud. SME has not filed for or obtained registration in and to the work. Henson is the only person with a copyright registration in and to the work. SME is not the author or creator of the work. They do not have a signed written work for hire agreement. They do not have a signed and written transfer of interest in and to the work from Henson. SME does not have standing to assert ownership of the work. None of the defendants possess any licenses to use the work. So, now we're going to get to the list of unauthorized uses. In 2024, SME entered into 2 licensing agreements for the use of the work in exchange for, at minimum, a licensing fee. SME entered into a licensing agreement with defendant Richmond Street Production for the interrupted use of the chorus in the work, in the main title of the motion picture Deadpool and Wolverine. Defendant Richmond made such commercial use of the work in the main title of Deadpool and Wolverine. A true and correct copy of title scene can be viewed at the link below. The chorus of the work appears at, and then he lists all the points of this kind of video, the opening sequence to Deadpool and Wolverine, where his dance appears. The excerpt of the work used in the main title is the chorus of the work, and it appears interrupted but unchanged and or unmodified. The chorus of the work is not being commented on, ridiculed, criticized, critiqued, or mocked by the character performing it during the main title of Deadpool and Wolverine. The Deadpool and Wolverine main title does not make any point about the work itself, so it's not going to come under fair use. Fans received the use of the work as a farewell to the 20th Century Fox Marvel Universe, which is the same message the work was created to convey when it was used to promote the musical work Bye Bye Bye. When Bye 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 was released, it was received by fans as a farewell to the group's manager, Lou Pearlman, and their record label RCA Records. The use of the work, referenced in paragraphs 45 to 49, incorporated herein by reference, functioned as a substitute for the work. Fans have renamed the work in its entirety as the Deadpool Dance or Dance Pool, and the choreographer that performed the work, defendant Nicholas Pauley in Deadpool and Wolverine, is being hired to perform and teach the work in its entirety in Henson's stead, which is a gut punch. It is a gut punch. I've seen it there's a new trend as well. I mean, I don't get why the younger generation are just taking old stuff that belonged to my generation, tweaking it and calling it their own. So there's another NSYNC dance, the one that belongs to I Want You Back, which is now being changed. I'm not saying I don't like this new dance. I do actually, but it is not the original dance. And I've got no problem with, new ideas and, trying to improve or modernize ideas, but at least reference, the original, to have some respect and do things justice. The original dance, it was a great dance. This new dance, I actually really do like it. They've modernized it and it's, it's sharper, it's quicker. But let's not pretend that this new, I don't like videos where they're just doing this new dance to this old song and then acting like it's always been that dance. Okay. So that was my soapbox moment out the way. Deadpool and Wolverine earned $1.338 billion globally at the worldwide box office. Now, that obviously wouldn't have been entirely for the opening credits, but there was a big noise about how it was one of the opening credit sequence, one of the greatest of all time. And it was because of that dance. In 2024, SME also entered into a licensing agreement with defendant Epic Games for the use of the work as an emote for purchase in the video game Fortnite. Obviously, people were literally paying for the ability for their kind of character to be able to do the Deadpool dance. So you can see where the profits are coming from there. Epic Games made such commercial use of the work for profit. A true and correct copy of the emote can be viewed at the link below, which I'm not going to open. The excerpt of the work used in the emote is the chorus of the work, and it appears uninterrupted, unchanged, and unmodified. Defendant Nicholas Pauley received several paid opportunities to perform and or teach the work worldwide following the release of Deadpool and Wolverine, including but not limited to Comic-Con. The use defendant Nicholas Pauley made of the work as referenced in paragraph 55 and incorporated herein by reference is both direct and vicarious. And he is a choreographer. So Nick Pauley would know how this works. He will know that, this work would have been subject to potentially to copyright. I can't imagine that he is trained as a choreographer and is not aware that this work belongs to Darrin Henson and has not said to anyone, hey, have you checked in with this guy? I would be surprised. Pauley was employed by defendant Richmond Street Production to perform the work in Deadpool and Wolverine and to likewise promote the same acts, for which Richmond Street Production can be held vicariously liable, which is what I was trying to explain earlier. So Richmond Street Production had their own license from SME to use the, to use the music, and I'm guessing they were under the belief that that included the dance in the opening credits of, Deadpool and Wolverine. But they are also vicariously liable as the employers of Nick Pauley. On information and belief, Dependent Pauley also made the same promotional use of the work independent and or outside the scope of his employment with Richmond Street Production, and solely for his own personal gain, and or specifically to advance his own career as a choreographer and dancer, acts for which he can be held independently liable. Ugh. Defendant Lance Bass partnered with the Marriott Bonvoy for an appearance fee or other valuable consideration for a dance experience at Heart WeHo in West Hollywood, that's California, on July 26, 2024. At this experience, Bass taught fans the work. I'm a little bit on the fence. I can see what he's saying, but I also think, this was a member of NSYNC. They kind of complemented each other's work. I would be I'd be less inclined to sue Lance Bass. However, I can see where he is coming from. So, in 2026, Henson learned for the first time that SME licensed the work for profit on at least 2 other occasions prior to the uses described in paragraphs 44 to 57 and incorporated herein by reference. Henson cannot lawfully disclose that information at this time, but will amend to add those individuals and their acts of infringement by amendment after discovery. Okay, so there is more. we can't know about it just yet, but eventually he will go on and amend his complaint, and we will find out. Okay. Plaintiff is not currently aware of any other uses of the work for profit. Notice. Henson discovered the use of the work in Deadpool and Wolverine around when the film was released on July 26, 2024. In August of 2024, Henson sent demand letters to all then known or believed related licensees of SME, Marvel Studios, Disney, and Epic Games. In response to the demand, SME requested time to find work for hire paperwork. They have been unsuccessful, and SME and Henson have been unable to reach an amicable resolution, necessitating the instant action against all known tortfeasors. So that's confirmation then that mediation was not fruitful at all. So they have come back from that now. This is the complaint being amended. Sony and the other defendants will be expected to respond. And this case, which for me was already fascinating and really exciting, just got so much more exciting. So it'd be interesting to see. I also want to know, what are the licenses? Who else are we suing? Are we suing Ryan Reynolds? Honestly, I really want to see that. Okay, so first cause of action against all defendants is copyright infringement. So I'm not going to go into it because we have just gone over it. He's basically saying, look, it's my work. He is the only holder of a copyright certificate in respect of this work. And without his authorization, then effectively any licenses to reproduce or distribute or publicly perform the work are void. And any money belongs to him. Which I went through in great detail. It's not just a case of, Sony being sued, they pay damages, and that's the end of that, right? This is massive. This is so much bigger than this. This is him saying that anyone in the chain, anyone who has received a license from Sony or anyone else to use his work, they all have to pay him, whatever, all the royalties and profits and anything else that stemmed from his work being used via any license. So this is absolutely massive. Vicarious copyright infringement. So that's against SME and Richmond Street Productions. Okay, so it's not against Lance Bass and it's not against Nick Pauley. Plaintiff repeats and incorporates by reference each and every allegation set forth in paragraphs 1 through 73 inclusive. Numerous individuals and entities directly infringed plaintiff's copyrighted work. Defendant SME authorized some, if not all, of the infringing acts alleged herein. Defendant SME had the authority and ability to control or stop the infringing acts. SME obtained direct financial benefit from the infringing activities of the individuals and entities. Same with defendant Richmond Street Productions authorized at minimum the infringing acts of Nicholas Pauley, John Likens, and Disney. Defendant Richmond Street Productions had the authority and ability to control and or stop the infringing acts of its employees and or agents Nick Pauley, John Likens, and Disney. Defendant Richmond Street Productions obtained a direct financial benefit from the infringing activities of Nick Pauley, John Likens, and Disney, in the form of, at minimum, the monies it earned from Deadpool and Wolverine. And that the acts then of SME Richmond Street Productions and defendants as alleged herein constitutes vicarious copyright infringement. So, what is Darrin Henson looking for? Firstly, a declaration that he is the exclusive owner of the work, the dance, and that SME does not have an interest in the work sufficient to confer standing on it to claim ownership of the work. 2, that the court enters judgment against defendants that they have infringed his rights in a federally registered copyright. Otherwise, injured the business, reputation, and business of Henson by defendant's act and conduct set forth in this complaint. 3, that the court enjoin defendants and their agents, representatives, servants, employees, attorneys, successors, and assigns, and all others in active concert or participation from licensing, copying, performing, posting, or making any other infringing use or distribution of the work. That's basically pull everyone together. They all have to stop. So that would stretch far, far wider than just these defendants. 4, the court ordered defendants to pay plaintiff's actual damages, when that includes his damages and the defendant's profits, which is, it's going to be, this claim is worth an absolute fortune. This is worth so much money if he wins this. 5th, the court ordered defendants to pay plaintiff both the costs of this action and the reasonable attorney's fees incurred by it in the prosecution of this action as a sanction pursuant to applicable exceptions to the American rule. 6, that the court grant the plaintiff such other and additional relief as is just and proper. Okay. Wow. So as a proposed order, I won't go into that. Proposed order merely is like, Judge, can you just sign this order that says, yes, so we agree, Darrin Henson can have everything he's asking for. So 2 big things in this complaint. It's largely the same, but he's added, several new defendants, big names as well. And he's also requested a change of venue as well from Georgia to California. So this is going to be interesting. I'm dying to know who the new defendants in the next amended complaint are. Let me know what you think, though. This is such an interesting case. I can't wait to see how it plays out. I'm genuinely really excited for this one, and I hope to God that Darrin Henson wins this. All right, guys, that's it from me.